CS BAR's meeting. And we have, as we normally do, first up on our agenda, some staff announcements, and then we're going to dive into the guidelines that we have been talking about as a group for the last several months. Before we do get started with the agenda, though, I did want to open it to public comment and give anyone who would like to speak to anything that's currently on the agenda or anything that they want CS BARs to know about any other items, to please do so now. And I believe you can raise your hand and be recognized.
Dean Gardina, should we call a roll?
Yes, that's the problem with not having chair notes. I skipped right over that. I think a roll would be very helpful. You'd think I'd had that by now. Thank you.
Okay, great. Well then, so Dean Clancy.
Present.
Dean Frickberg.
Present.
Mr. Kramer.
Present.
Mr. Murphy. Dean Pritikin. Dean Gardina.
Yes.
Dean Park.
Present.
We have quorum. Thank you.
And so this is a problem with not hand holding. So now I believe we're okay to go to public comment. And so anyone who'd like to address the committee can do so by raising their hand, and they'll be recognized.
I don't see any hands.
Okay, given that there's no public comment, why don't we go ahead and move to the staff announcements?
Might I suggest we start with the minutes if we may?
Absolutely. So, right, everybody should have received a copy of the minutes, and they're also attached to the agenda. So are there any changes or anything that needs to be addressed based on the minutes as they've been posted? Okay. Seeing none, do I have a motion to approve the minutes as posted?
I make that motion. Second.
All right, Ashley, can we do a roll call vote?
Yes. So Dean Clancy.
Aye.
Dean Frickberg.
Aye.
Mr. Kramer.
Aye.
Dean Gardina, or sorry, Dean Park.
Aye.
And then I see Mr. Murphy has joined us. So Mr. Murphy.
Yes.
Great, and Dean Gardina.
Yes.
The motion passes.
Now I think we're okay to move to staff announcements.
Certainly. Sure. So I'll take that. The first thing I wanted to talk about was the implementation of the NPR. So the school reports for the NPR are due on July 1st. And this year, to respond to the changes that the committee made responsive to the provisional licensing program with an alternative pathway to licensure, all schools are reporting in 2 steps. The first step mimics the calculation in past years. All schools will provide that by July 1st. And then as soon as possible thereafter, they will be advised as to the number of individuals who are in the alternative pathway to licensure, as well as the number of students who have completed that pathway through licensure, so that the final number can be adjusted. And I'm very pleased to report that though the schools were not required to do so, nearly every school has been extremely responsive in turning their materials in the requested format prior, so that some of the initial validation steps can be completed prior to July 1st, making it easier to get the PLP adjustments out to the schools. We've received very few questions, but we are of course available for any schools who do have questions about the calculation. And I'd like to thank the schools for their cooperation and for their proactivity. Any questions or comments on that topic before we move to the next?
And Natalie, can you just describe, and again, I apologize, I have an unstable internet, so hopefully you can hear me, and that's why my picture is posted. Can you describe again how the State Bar staff will update schools as their graduates proceed through the PLP program
Yes, so
and successfully complete it?
the inflection point is July 1st. And so all of the schools will get an adjustment number as of that date in terms of the number of students that are in the pathway, as well as the number of students that have completed the pathway. And at that point, because the initial validation will have been done, we'll be discussing within an agreed upon universe and just determining if any of those students are in the pathway or have completed it. And as a practical matter, most likely for this year, you will have students or graduates in both categories. But by the time of the 2022 NPR reporting, because that window has closed in terms of applications May 31st and will close in terms of completion next year, June 1, 2022, everyone who plans to complete will have completed by that next reporting next year.
I have one question
Sure.
for Natalie. Natalie, regarding the people who are in the pathway program, those who have to file their application for a moral character determination, how long do you expect it will take before they can be approved to begin? I know there's some sort of a preliminary review that has to be done for that determination for them. Is there an estimate as to how long that'll take?
It depends, and that's part of the reason why even before the PLP program was approved in the fall, we started making announcements encouraging people to apply, and also we made additional provisions in the moral character unit to try to keep everything moving in that regard. I don't know if Audrey has a time estimate.
It's posted on our FAQs too. So if you look on the provisional licensure FAQs, it's question number 25, saying that the moral character applications take 2 to 3 months for initial review.
Thank you very much.
Mhm. Okay. All right, moving on to our second topic, the accredited law school rules. So the rules were approved by the Board of Trustees to take effect for accredited law schools on January 1st, 2022, with a 2-year phase-in period. So this group has been talking about guidelines against a proposed set of rules. So I'm pleased to report that set was adopted. And you can feel confident that your work is going to apply to the rules that you were in fact thinking about. They will be posted sometime over the summer, well in advance, as well as we'll be providing rollout materials. And as part of the fall annual report, the report will be focused against the current rules, but there will be a readiness section in which we challenge the schools to review these rules in advance, determine what is needed, and assess their readiness and the support that they may need from the State Bar as well. So look forward to further discussion of feedback and recommendations about guidelines later today in the meeting. Okay, any questions about that? I think probably this group, you are experts on this topic.
I think it's great that there is something of a readiness section. My only question was, when would that be available to accredited law schools and maybe to applicant institutions for the accredited level?
It's usually issued around Labor Day, and that's what we would expect this year as well.
Great, thank you.
Mhm. Okay, I'll skip number 3 because we have a special guest coming to do that staff item at 1:15, and I'll just proceed to number 4, which is just a reminder announcement of committee vacancies. So each year, several positions open on committees, including CS bars. The original posted deadline on our website was February 1st for applications to CS bars. This year we know was a most unique year for all of the law schools, and many deans indicated that they were unable to know what their schedule and availability would be at that time for future years due to COVID. So the deadline was extended first to June 15, and that was announced in the newsletter in May. We received a number of applications, but also the decision has been made to further extend that window to June 30th. So that will be posted and may already be posted on our CS Bars page of the State Bar's website. And after this meeting, we will send out a message to all deans of registered and accredited law schools. So everyone will get it, including all of you. We know that you're already part of the committee, and we thank those that will be completing their term after the August meeting. Dean Gardino, our chair, as well as Dean Pritikin, not here today, but as always, has done his homework in advance and shared his feedback with Dean Gardina. And speaking of the newsletter, just a reminder, we send it to the deans, but now there is a subscribe button on the bottom. And so you can forward it to anyone on your staff. And if they feel like it's relevant to them and their jobs, they can go ahead and subscribe, and then all future issues will automatically be sent to those staff. So I don't know if anyone here has taken advantage of that new option, and hopefully it's helpful for everyone. Okay, so those are my items, and I'll take a moment to check with Ashley to see if our guest speaker, Lita Abella of the Lawyer Assistance Program, has arrived.
She is here, so let me promote her to a panelist.
Okay, perfect, thank you.
Lita, you should, okay. And here she is.
Hello, everybody.
Welcome.
Hi, Lita.
Hi, nice to see everyone. So can I go ahead and start?
Yes, would you like me to show the attachment that you sent me yesterday?
Sure. So thank you, everyone, for inviting me. I'm going to be very brief and to the point. So I just wanted to introduce myself. I'm from the Lawyer Assistance Program of the State Bar of California. And in addition to providing a free 1-hour MCLE presentations to attorneys, I also conduct outreach to law students and State Bar applicants. And I conduct presentations to law schools, student bar associations, conferences, etc. And I wanted to let you know that I'm available for your law students at your law school. My presentations consist of 30 or 45 minutes, or could even be shorter than that, depending on how much time you have available. I can be there for your orientation week. I can do a lunch hour program if you're having like wellness week. I can be there for a professional responsibility class and pop in for 10, 15 minutes, whatever time is available and convenient for you and your law students. My presentation is entitled Reset, Recovery, Renew Wellness Strategies for Legal Professionals in the New Normal. And as you can see on the screen, I talk about what causes legal professionals to suffer from substance use and mental health issues. I talk about the stigma and overcoming it. I discuss just a little bit on moral character issues, but I always refer them to the Office of Admission and Moral Character to go into detail about that. And then I talk about the Lawyer Assistance Program, which they are entitled to as law students and bar applicants to our services. Some are free, some have cost to them, and I explain that. And then I also talk about other resources that are available. So I just wanted to let you know that I'm here at your service, and to please reach out to me if you would like me to come and talk to your students. I can do this online or virtually, whatever, again, is convenient for you. My contact information is on the screen. If you have any questions or comments, I am more than happy to answer them. Thank you very much.
Thank you, Lita. And I just to boost what you said, first, thank you for coming to my law school, the Santa Barbara and Ventura Colleges of Law, and doing a presentation. And also, when we first sent this information out to our students, when you first promoted it, several students got back to us and said they'd reached out independently to your office and they received some resource and service information that they needed. We are doing an attorney competence and wellness course this summer, and it's being incredibly well received. I think students are much more willing to talk about the struggles that they've been having in COVID as well as in law school. And I'm so appreciative that the state bar is reaching out to law schools and law students, because I think catching them now before they enter the profession is such an important thing. And I would really encourage other law schools to reach out to the office too. Our students receive the information very positively. So thank you for that.
Thank you. Yes, I do remember attending your school virtually, and I did receive a lot of positive feedback about that. And one thing I was going to mention too, my presentation is interactive, and so I have polls, and it's, you know, I know we're all going through a lot of Zoom fatigue this past 15 months, but I make it very engaging. I have videos. And so a lot of the comments that I get is, oh my gosh, I didn't want to blink because I was going to miss something, because there's always, you know, it wasn't a boring monotone type of presentation. It's very engaging, and the students and attorneys love it. So please reach out to me. I'm here at your service, and we're all here because we all have a common goal to make sure that we're staying healthy and wellness and so forth. So thank you very much for inviting me.
So Lita, this is Natalie. If a school wanted to schedule you for part of their orientation, do you have a target by when they should reach out to you?
The sooner the better, because I have some bookings already in November, December. It all depends on the day, the time. So I just have, you know, the sooner the better in any time in scheduling.
Okay, great.
Thank you.
Thank you. Dean Gardina, this concludes our staff report.
All right, wonderful. And I'm wondering, under recent developments, and just to ask Audrey, anything about the upcoming bar exam or about anything related to that you think it would be helpful for the deans to know, so we can work with our graduates and make it as smooth as possible?
I would definitely encourage everyone to read the July bar exam FAQs. They've been updated a couple times this month for changes with the new version. There's a new version, 2.72 of Exemplify, which I think if you read through the changes of how the performance test will look. Also, there are built-in warnings now for when applicants don't meet the minimum system requirements and ways that they can make sure that they are connected to their audio. And then I'm going to start sending those weekly emails starting this Friday to everyone who is registered for the exam in July, and I will forward those to all of you. So make sure that you, Ashley and Natalie, have the right people for your schools on their list, and I'll start sending those on Friday, up every Friday up till the exam.
Thank you, Audrey. And I know that another question that has come up, and I'm assuming that neither you nor the CBE have had the opportunity to consider it along with the Supreme Court, which is the NCBE announcement regarding the MBE and online options. So I think that's probably something that our students are thinking about. It certainly has come my way about whether or not this online option will be available after the pandemic is done, whenever that may be. So I imagine that's something that's coming up in your considerations, but I don't know if you have anything to share regarding that.
I mean, no, I mean, the NCBE put that public announcement out about in-person testing for February 2022. So I know what you know.
Just a helpful addition to, and I don't know if this would apply to all law schools, but Audrey was very helpful in actually handing this inquire me from emails. So, and Audrey, feel free to correct me if I got it wrong, but with regards to the acceptance and acknowledgement of testing conditions for the online exam format, there's been a good adjustment this run that it's in the bar exam application. And so since that's available in the Ames portal, students can go back there and be able to see a copy of their application plus any declarations they've made in relation to testing conditions. And I just think that's such a great improvement. Just something that is accessible online for the student to refer back to is great. And I inquired about this because I was wondering for this run, you know, should law school deans kind of talk about those conditions or make sure to, tap students on the shoulder to see those, but it's already been taken care of at the bar exam application level. And we're very happy to tell students you have now this online way to refer back to that if you're ever confused. So just wanted to mention that.
Thank you. Yes, we are also very happy about that, being able to make that change, since we had the announcement from the Supreme Court ahead of when the application opened. It's much, much better for applicants this way.
Great. I did have a question about a prior topic, just for the CS bars or maybe even for the applicant. And if there's no answer yet, that is fine. But just because of the recent news of, what's opening back up at this time, I was just curious in terms of, let's say, CS bars or committee meetings. Is it somewhat set that there's a date where those would be on site, or would those, is the kind of status quo of it's sort of virtual until a point of announcement? That was just something I'm curious about. And I think CS bars dean applicants maybe as well, although of course they could be open either way.
I think it's more the latter, where right now it's status quo of how we've been doing meetings. We also have our new executive director.
Yes,
So there'll probably be a review of how all the public meetings have been during this time, and which meetings should come back in person and when or how often. And so I imagine that there's going to be a whole review of that, but for now we're going to keep it this way until further notice.
Great. And then if it did get announced, would it kind of be just announced on the website, or just more to, people to their respective committees?
I imagine that we would post, because we have to post everything about how our meetings are, but we will, I'm sure Natalie and Ashley for this committee, once we have an idea of how meetings will proceed, we'll let everyone know.
Great, thank you.
Not only for the members, but also for the public to know how to participate.
I would just add, and I have no inside knowledge about how meetings will continue, but I do know that the governor extended the changes to Bagley Keene as a result of the pandemic through, I think, September 1st. So at least teleconference, Zoom type of meetings can continue as they have been until that date, at which point, all of the pre-pandemic requirements are going to presumably take effect again. And that may, impact, it may not mean no more Zoom meetings, but it may impact the way that we conduct Zoom meetings to make sure that we're in compliance with the notice, with the normal notice procedures, which have been somewhat relaxed as a result of the pandemic. So,
thank you. That was really helpful.
And that's actually allowed until September 30th. So we have 30 extra days than what Caroline said. So that gives us a little more breathing room. No problem.
Appreciate that.
All right, well, thank you again for all the information that you provide at these meetings. And now really we want to get to the substance of why we're here, which is to really consider and vote on potentially the recommendations that we as a committee would make to the CBE regarding what guidelines are needed, and also what they might say. I would encourage, again, all of the deans who perhaps have not dived into the rules to do so, and I'm sure that they will identify some areas that might need clarification that may not seem evident to those who lived and breathed the rules for a year. So I think, Natalie, anything that is identified can be sent to you as a notation that might want to be considered, or questions that come up or areas of confusion we might want to clarify. Is that accurate?
Yes, that's fine. Or people can always use the general mailbox, the law school regulation at calbar.ca.gov. And this way, all of the departments that need to see it, I can share.
Okay, great feedback. So to that email, make sure that not just Natalie sees it, but multiple departments within the state bar can see it and assess it. And I'm assuming that means perhaps OGC and others who might need to take a look at what is being considered. So Natalie, I know that you've prepared a PowerPoint that would kind of set the stage for where we are in the guideline process, what CS BARS has done up to this point, and then where we're going to go forward from there. And so I don't know whether you want to share that, and we can kind of take people through it, especially those in the public who may not have been as attentive through this entire process.
Yes, please. So Ashley will bring up the PowerPoint and we'll just do a very quick background so that everyone is on the same page of where we are at this time.
Sorry, one moment. I'm sharing my screen.
Thank you. And we've been using, for reference, we've been using the same PowerPoint actually for each process because the initial feedback was submitted in January along with this feedback. This time, I did need to make one adjustment, just recognizing that in fact, the rules had been adopted by the Board of Trustees. So we can move along from this title page. So just quickly, of course, CS BARS was deeply involved in the creation of the rules starting in April of 2019 through to now. Back in November, the Board of Trustees reviewed the agenda item with both a CS BARS proposal and a committee proposal. They posted the committee proposal for public comment. The committee reviewed that public comment that was received. And then in May, the new news since CS BARS was together is that the board adopted the rules effective January of next year. Next slide, please. Just a reminder as to the relationship between the rules and the guidelines and how they are created at the State Bar. Rules are adopted by the Board of Trustees. Guidelines are there to interpret those rules. The committee can adopt guidelines after seeking feedback from CS BARS and also public comment. And that may be received at meetings or also between meetings. And we hope that the general email has made it easier for people to submit that public comment as well. Next slide. So the CS BARS charge for this portion has been to look at the rules and to determine which of those rules could benefit from additional detail or clarification to help the law schools understand how to fully comply. So CS BARS quickly sprang into action, submitting quite a bit of feedback in January 2021, modifying it really only just a bit since then. And at each meeting, the committee has been going through a different section of the rules in January, March, and April, and most likely concluding today. Next slide. And just a reminder, I know that this skeletal framework is very familiar to everyone on CS BARS. You divided your comments in terms of sharing the work, but also the rule structure has an implementation process. How do these rules come into being? Accreditation process. How do schools access the new jointly accredited status? What are the substantive requirements in your 4 pillar areas listed there with the dashes? And then finally, when there are issues or potential issues as to a school's compliance, how is that process handled? Most of these topics are in gray because in fact, you've gone through those sections and also brought in the Council on Access and Fairness to help review the diversity, equity, and inclusion portion. So today, you'll be continuing with that non-compliance section, some of which you discussed in a preview fashion at the last meeting, and then just going through the proposal overall. We received some general comments prior that we'll make available today. So those are the slides I prepared just to catch everyone up as to the process.
Thanks, Natalie. And just again, a reminder about our goals when we set out on this project in both creating the rules as well as our hopes regarding the guidelines was that the rules would be really the basis of the accreditation piece and the guidelines would play a small part. Our goal in crafting these rules was that hopefully we would capture most, if not all, of what was needed in order to ensure quality legal education and compliance with all relevant accreditation issues within the rules themselves. Obviously, ambiguities arise that will need to be addressed, and those would be addressed through the guidelines. So as Natalie pointed out, we had the deans go through those rules, identify areas that they might be confused about, and offer some clarifying language that we could put alongside that rule, and hopefully recommend to the CBE as potential guidelines. And before we move forward on the non-compliance one and then circle back and look at all of them before we vote on a recommendation, Natalie, can you speak to the staff's process itself? I'm sure the staff is going through the rules as well. Will you be making, as a staff, recommendations to the CBE about guidelines?
Yes, so staff will be also creating a proposal, but delayed creating one until receiving all of the feedback and discussion from CS bars. And so over the course of the summer, most likely at the August meeting, we'll be presenting a staff proposal, but it will be informed by your discussion as well as the additional questions that we have been receiving inside from schools as well.
Okay. So at the August meeting, we'll have an opportunity to take a look at staff guidance, and I think that really helps bring us to because some of the questions that have arisen really among the deans is well, what does the staff need for some of this, and we can certainly hear from you either during this conversation or when staff comes forward with some of their recommended guidelines as well. But the one kind of guideline that we hadn't resolved or had a discussion about was some language regarding the non-compliance and the probationary piece. And I don't know, Natalie, if you've got that piece up, but it is towards the end of the rules document.
Yeah, so I'll ask Ashley to bring that up, and it's the 4.172 section. And while she's doing that, I'll just tangentially mention something else that may be on your mind. With the committee adjusting the minimum bar pass formula, that is integrated into the rules in this new proposal. So we'll be looking at that to make the appropriate adjustment to reflect the proper calculation going forward in these rules. So you don't have to worry about that.
Okay, so as you can see from 4.172E, Dean Pritikin, who's unable to be with us today, unfortunately, had raised a number of questions that he identified as it related to the probationary period rule. I did have an opportunity to speak with Dean Pritikin about kind of what his thinking was, and did he have some recommended language, since right now what we have is some questions, but no recommended language. So Dean Pritikin and I did kind of craft a very brief potential guideline as it relates to answering these questions. And I think it might be easier to present the crafted language, and that way people can react to it and we can see whether or not it answers the questions or whether it raises other questions, and leave it there. So I don't know, Natalie, I have the language recrafted. I don't know whether you have it easily available as well.
We do. We're about to bring that up now.
Great.
So here, is this what you were intending, Dean Gardina? Oh, Dean Gardina, I can't hear you.
Yeah, well, and I know I fell for the "are you on mute" problem. So the language that we came up with based on all the questions that Marty had asked and raised, and I think, Natalie, you received some comments or other information from other committee members as it related to these questions as well, was to clarify in the guideline that it's no earlier than 6 months prior to the conclusion of the probationary period. We believed that reflected the staff and CBE's thinking about that language no sooner than. The committee may sua sponte So again, something that was left unclear whether it was something the committee could do on their own or whether it had to be the result of a request for an extension. So the committee may sua sponte or upon a written request from the school, so leaving both opportunities available, extend the probationary period for no longer than 2 years from the date of the extension. Now, I think Marty felt it was important, and I think others commented on this as well, Natalie, that there be a definitive limit to the probationary period, whether it's 2 years or 6 months. What we didn't want to have happen, I think, is no limit, and a school could be on a probation for an extended period of time with no end in sight. So this was a starting place for a discussion about the limits or how this would occur in terms of extensions. And I welcome any feedback from the committee on this language and whether or not we captured and answered the questions that Marty had originally presented.
So one thing that I'll suggest, although I certainly would defer to the committee and return it to them, is as far as having an upper limit, I do hear that feedback. The general discussion that I heard was to contemplate more of a small or de minimis extension to the probationary period. So needing to complete the library by a certain day, but one book is on back order for 3 months, that sort of thing. So I'm not sure what amount of period of time they would have in mind, but it's very helpful to have this feedback from CS BARS and a starting suggestion that we can share.
And just in response, I think the idea, and it could certainly be crafted better to say, I think it was the idea that it could be less time. It could be a month if that's what CBE warranted, that would be in their discretion. But that CBE couldn't extend it 5 years, and that school had a probationary status for an extended period of time. So I think it was within the committee's discretion, but with a limit on the length of the probation.
Thank you for that clarification.
Jackie, this is Greg.
Yes, great.
I'm wondering if we should add a sentence here that puts a standard in the document for purposes of deciding when extensions should be granted. That is, I don't think extensions for probation should be routinely granted, but there should be some showing of extraordinary circumstances or something like that. I thought we had discussed that before, but maybe it was a different context.
I don't have the rule in front of me, but I thought there was some language to that effect in it, wasn't there, Natalie?
I'm going to pull it up and check, but I know that that was part of the discussion. So for example, one thing that was discussed was that something like the MPR, for which there is significant notice, would not be something that the committee would consider for an extension. But I don't believe that it is.
Yeah, it's right there on the screen in the bold.
In this part?
I put it on the screen again. Would it be helpful for me to have the side by side, perhaps?
Might be too small to see.
Oh, yeah.
Let's see. So
Anyway, if you look there, the committee has to make specific findings that extraordinary circumstances justify it, considering the progress made to that point, and other relevant information. So does that address what you're looking for, Greg?
Yeah, that's. I remember we having a discussion about that, so I'm glad it's still on there.
Yeah, so that's in the rule.
Yeah.
So I think that it's, and I had a big part in writing this, I think. And my intention was that it would be in the last 6 months, or the last 6 months of the probationary period was when we would talk about it. We didn't want extensions being granted at the front end. We thought 2 years was time enough to show progress. And if you didn't show progress, probably that's the end of it, unless there's really extraordinary circumstances. So, Jackie, frankly, I'm a little surprised that the schools are concerned that we might be too generous. Accepting the input, of course, but
I think it may have been an opposite concern, not too generous, but I understand your position. I think, and I'm trying to speak for Marty, and hopefully I'm capturing it. Was that CBE could have a school on probation for an extended period of time, and wondering about what that would mean for students, what it would mean for the school. And so kind of that idea of there needs to be a time where the opportunity to be successful has ended, and the school knows, the student knows, and the CBE can.
oh, looks like you froze. Well, yeah, I personally don't see a reason to set a specific limit, but if it makes you folks more comfortable, I'm also not against it. I just worry about, there's always the weird case, and it doesn't come that often, but where, everyone agrees that it would be a good thing to give a little extra time, and hard limits, might frustrate that desire.
But Paul, I'm wondering also, so the way that the rule is drafted, it suggests that it would be upon request only, and the guideline that Jackie and Dean Pritikin are suggesting puts in that the committee can sua sponte, extend somebody's probation. And it seems like if you just take out the sua sponte part and you're just doing it based on the school's request for an extension and showing of extraordinary circumstances, I mean, there's really no risk that they're going to be put on ice it's at their own request, I guess.
Yeah, I'm not sure when the committee would need or want to take action without a specific request from the school. It's going to have to go on a committee meeting. It's a full committee decision, so it has to be a public decision. And I don't know if this is just hinting at running up against a deadline, imminent expiration of probation, and needing to quickly extend it. I think the schools are going to have to plan ahead and keep their eye on the calendar. And if they need more time, make their request ideally right about the 6-month time. In fact, I vaguely recall that when we set 6 months, we had in mind that it might take a little while for staff to investigate the circumstances and prepare a report. And so we wanted to make sure that there was plenty of time to do that before the period actually expired.
This is Dean Park. I noticed that we may have lost our chair, so I was trying to.
I have returned via phone. Can you hear me?
Yes.
Yes. Yeah.
Okay. All right.
So glad to have you return.
Okay. In some form.
So I think if you have missed anything, I believe Caroline was mentioning something about the sua sponte or upon written request, and what circumstances can kind of lead to either one being probable. But it seemed more likely written request would be probable. Was that the?
Yeah, well, I was just pointing out that the way that the rules are written, it appears to be that an extension would only be considered upon written request of the school itself, not upon the committee's own action, just sua sponte. So I guess I was wondering if that would alleviate your concern about not having too long of an extension period, because presumably the school is the one that's asking for the amount of time that they want the extension to be for.
Mhm.
Ashley, could you scroll back up to the actual rule language?
And Caroline, and again, I'm trying to speak for Marty, and I don't know that I'll capture it well, but if you read the first sentence of the rule, it looks like the committee has the discretion to extend the probationary period. It's not till the second sentence in the rule in which the extension request comes in. So I think there was some conversation about clarifying that the committee had the discretion to do it on their own. And I don't know whether in reading the rule, you see that same ambiguity.
Yeah, no, you're right. It's yeah, it just refers to request in the second sentence. But why would the committee ever want to extend the probation if the school didn't ask for it?
It sounds like, and again, just looking at the rule, if we're implying sua spontes being implied in the first sentence, it's if the committee makes specific findings that extraordinary circumstances justify the extension. But I agree, I'm not sure if there's many cases where the committee would do that without the law school bringing the request.
I mean, it's kind of, you know, one of the themes we see in compliance cases is, you know, or we look for that the school is serious about making things better. And if they can't get around to requesting an extension even, seems like they failed that test.
Then perhaps the guideline, if the CBE is not interested in having the authority or doesn't read the rule that way, is simply to suggest that the school has an affirmative obligation to submit an extension request no earlier than 6 months prior to the conclusion of the probationary period.
Yeah, and just kind of encourage them to file it in the early part of that window rather than at the end, to allow time for processing, you know, maybe some, you know, back and forth conversation between them and staff, or between them and the committee. So if they first file it and it shows up in a not perfect condition at, you know, the month before the probation expires, that could be a problem. Allow time to work out the kinks.
Well, and I would assume, Natalie, based on staff and the processing and getting it on the agenda, there would need to be a date certain in which someone would need to submit it before the end of the probationary period to ensure that a decision could be made by the CBE.
Likely, yes. And I would make the assumption that as we're working with the school, we would continue to remind them of this provision so that they could make the appropriate adjustments.
Although, Natalie, probation is not, the end of probation is not self-executing in that it terminates the accreditation. We have to then take action still, right?
That's correct.
But it does create, I mean, that's not the place the students would want to be in. That probation expired and we've started an enforcement action. So it's still advisable to get it in early, but not fatal.
Well, and if you look at F in the rules, you'll see that there is a 30 days before the probation expires provision. So one would assume any extension would need to be submitted by that time when the committee sets the date.
Yeah. Okay. Well, we can take care of drafting something like that. Just, just provide friendly reminders to, if you need more time to get it in early, address the standards that we have to apply, and let's see. Yeah, I think we got it. I think I understand you, Natalie.
I do. And as a kind reminder to everyone, the focus of the State Bar, of course, is on prevention. And so we work with the schools to prevent issues in the first place. And if that's not possible, then we do try to talk with them as much as possible, remind them of what the responsibilities are and what the timeline is, and that won't change.
Is it possible to bring up the suggested guideline one more time on the screen share?
Possible. Could we go back and talk about the maximum probation extension of 2 years? I'm curious as to why that's being proposed. And I find that I rather agree with Mr. Kramer that it would be better to not have that wording in there, because there must be times, or there's likely to be a time when the thought is that the probationary period should be longer.
Well, we did want to limit the initial period to 2 years, but are you speaking about the renewed period?
I'm talking about the end of the wording that's on the screen now that is talking about a probationary period for no longer than 2 years from the date of the extension.
Yeah.
Is
gotcha,
that wording
yeah.
that's being proposed now that wasn't in the rule before?
Yeah, the rule is silent about how long an extension could be. You know, trusting the good judgment of the good judgment of the committee, and you know, not expecting us to you know, to just let things fester, or kind of, fester is the wrong word, but anyway, kind of hang around in a state of limbo, rather than resolve themselves as soon as they can be resolved. So yeah, you know, we could take your recommendation forward to limit it to 2 years if that's the committee's desire, but I, you know, I just sort of look at my calendar and wonder when 2 years limitation is going to be inconvenient for some reason, you know, where everyone agrees that a little more time would be appropriate.
I agree with that comment.
I just think the purpose of the guideline really is to help interpret the rule. So if there needs to be an addition here about, you know, a guidance to the law schools about when to apply for the extension on probation, I think this could be converted to that. But maybe if it's something about a hard limit, maybe it is appropriate for that to be more of a revisit at the rule level rather than tagged on as a guideline.
So I just want to make sure that we capture the edits that folks have been talking about, where you can see them on the screen. Is it correct that the suggestion is at minimum so far to remove the sua sponte language from this guideline?
I think that's correct.
Well,
Sua
and then,
or can be stricken.
okay, so we'll strike that, and then also, I know that the discussion is presently continuing as to whether or not to include a time period. And I apologize for breaking in on that discussion.
Chair Gardina, may I ask again just about the 2 years and what it may be preventing? And again, thinking that the guideline is helping with interpretation of the rule.
Yeah, no, I think Jessica, you raise a really good point, which is, does the proposed guideline actually create what we were trying to avoid, which was a new rule in some cases embedded within the guideline? So, and again, trying to speak for Marty, and I hesitate, and please, with all the caveats that go with trying to extend or speak for someone else based on a conversation that I had, I think the concern expressed was that a probationary period could be as long as 10 years or something like that. And what would that mean for students or anything else related to the school, and to somehow cabin the discretion so there was a known termination date. I'm not tied to that. I think, Jessica, you raised a good point. I think, Paul, you've raised some good points about what it is that the CBE is interested in, and that there might actually be good reasons for a 36 month instead of a 24-month or the like, or a 30-month given circumstances. So trying to communicate what Marty was thinking, what I've heard from Mike and Paul and Jessica is that there isn't an appetite to embed a limit in there, and there's even a question about whether or not it actually is an interpretation of the rule, which is what we're going for, or whether it's actually adding something into the rule that's not currently there.
No, thank you. I think
So
you
what I,
summarized that well.
yeah, so what I've heard is really more of a procedural guideline if necessary, which is no earlier than 6 months prior to the conclusion of the probationary period. The law school may seek an extension of the probationary period from the CBE, and I think that may even be unnecessary based on what's embedded in the rule already. But I welcome others' thoughts on that.
I think if there's a concern of what the law school should be doing in relation to the rule, I'm not against having a guideline there that clarifies, or I think even has what Paul Kramer said about the timing that a law school should choose to do this. But I agree overall that that if there's going to be something that really affects a maximum length, I think that's better off becoming a rule level discussion rather than guideline.
And Jay, I think you may be the only one who hasn't spoken about this. Any concerns about it? Thoughts?
No concerns. I don't think it really helps interpret as it is there.
Yeah.
Or leaving the sponte, I think it would be helpful because that was not expressly stated in the rule. But the idea of a limitation, I think is, I would be neutral on that. I don't see any benefit.
Okay. All right. So and we can follow up on that. It sounds like, Jessica, you're comfortable with clarifying that the earliest that a school can submit an extension request would be 6 months prior to the end. And certainly to a certain extent clarifies that it's an affirmative act on the part of the school that would trigger an extension decision by the committee.
Yes, I am comfortable with that.
Okay. All right. And I apologize again that my internet went out, but does that, Natalie, capture where we want to go with that particular recommendation?
I just want to make sure that I've captured the discussion because I've heard a few different points of view. I want to make sure that what we show on the screen reflects the preference of the CS bars.
Could I just make one additional comment, and that is that by taking sua sponte out, it seems to me that you would be changing the situation from what's stated in the rules. You're making it mandatory that there be a written request this way. And that's different than what the rule states.
Well, I would say that the rule is in the first sentence. Can you scroll back, Ashley? Is ambiguous in the first sentence, but in the second, it makes it clear that there needs to be an extension request. And logically, that would not come, the committee wouldn't request of itself. So that would come from somebody who's interested. And I think that leaves only the school to make the request. I don't see any need to give the committee the ability to do it on its own. If the school won't ask for it, then we move forward with the compliance process.
I think Dean Clancy may be the it could be said the guidelines helping to clarify the ambiguity in the rule, if there is any, that a written request from the law school would need to be made and what time frame they need to do it. That would be my view in terms of if there's a value in adding a guideline here, it's clarifying ambiguity in the rule.
I'm all for adding the guideline as it was proposed. I'm just suggesting that taking sua sponte out all of a sudden makes it such that the extension has to be requested by the school and can't be suggested by the committee itself. So I think that by taking sua sponte out, you're creating a situation where there's a requirement that is different than what's stated in the rule, rather than just a guideline.
I have a question for Jean and for Caroline related to that. The way that the rule is written at this time, is it contemplated that from the rule that an extension request could come from a committee member or the chair of the committee, obviating the need for sua sponte in the guideline? I'm not certain why that would be made, but could they?
I think Paul was right that it should say in the rule itself that this is upon request by the school. It doesn't expressly say, I mean, that's what if I was drafting it, that's what I would have drafted. But I think if that's not the committee's intention, I mean, this is an interpretation question, right? And this is what guidelines are intended to address, is the interpretation of a rule. I think CS Bars is interpreting the rule to allow the committee to, on its own initiative, extend probation. And Paul is saying, well, practically speaking, that's not likely to happen. So that may not be the committee's interpretation of the rule. But I don't want to speak for the committee, because maybe they are on the same page and they think that they should be able to extend on their own motion at a meeting. But I think what Paul's saying is right. Like, well, we have to notice these decisions. I mean, ahead of time, there has to be something that causes the committee to agendize consideration of the extension of probation. And logically, that would be a request from the school, I think.
Or let me make a schools' rights argument here. Would it seem maybe a little bit presumptuous on the part of the committee to be extending somebody's probation where the school doesn't want to do it? They would lose a little bit of control over their status.
Yeah, I mean, I guess on the other side, maybe it prevents the school from going, getting farther along in the termination process. But the way the rules are laid out, I mean, it's supposed to be very clear. This happens, then this happens, then this happens. And yeah, you would think the school would want to be in the driver's seat of intervening in that.
Yeah, if I were a school near the end of the probationary period and I wasn't sure that I'd made the staff and the committee happy, I would probably both file my proof that they should be happy, but also perhaps add a requirement for an extension of the probation to the extent that they are not happy. And just file in the alternative, and then, but it's up to the school. But there may be a school someday that's just litigious and wants to fight about not meeting our standards, and then would take offense if we just continued their probationary status, for instance.
I have to say, though, I think that would be, I mean, usually if there would be a fight, it would be, oh, there's harm. Right. And there could be harm, I guess, being seen in a continued probation, but usually the greater harm would be something very negative occurring faster than anticipated. Right. So,
yeah,
I think, again, just with the goal of if the guideline is going to be there, it's going to help with interpreting the rule correctly. Again, if it's about guidance to the law schools about when to submit their written request in relation to the scenario, I think that wouldn't hurt. I think that would be helpful. But I definitely, I'm taking Dean Clancy's point. there's no attempt here really to override what the committee has latent authority to do. And I think what's tricky is just that interpretation of latent authority may differ, but yeah, there's no
Well,
need
and
to overstep
just
that if that's something to be overstepped here.
well, and let's remember, by removing sua sponte, that doesn't mean that the committee doesn't have that authority if it in fact interprets the rule to include that authority, so that the guideline doesn't become the operative statement. The rule does. So if what we're attempting to do with the guideline is simply to provide guidance to the school on when it has the affirmative obligation, or the earliest date it has the affirmative obligation or can submit a request for an extension, then the guideline can do that. I think by removing sua sponte, it in no way prohibits the committee from sua sponte doing it if in fact at a later date it decides the rule actually includes that authority, which given our conversation today suggests that there is some ambiguity in there. Or Paul, it could be that in your conversations with the CBE, they decide that they would like the guideline to reflect that authority specifically, or to interpret it to do that. But I don't want to necessarily try to craft the perfect guideline as it relates to whether or not it has the authority, the committee has the authority or not, because if it exists in the rule, then it does. The guideline couldn't either take that away or add to it.
I agree with that.
Shall we take a moment to
So,
edit?
yeah, so and unfortunately I can't see what you have on the screen, but as I understand it, what we've decided to do is to say no earlier than 6 months prior to the conclusion of the probationary period, the law school may submit an extension, a written request to extend the probationary period.
And then we stop at that point. Okay.
Does that reflect what we tried to capture?
Yes, I believe so.
I agree.
Agreed.
And I see that
Great.
Mr. Murphy's hand is up. I don't know if that's a remnant or a final comment. Sorry, I know that Jackie can't see the hand, so I will
I
be,
cannot, I
I'll
apologize.
be sharing those with you.
Okay.
Okay, and it was an errant hand, I believe. Okay.
All right. Apologies, Greg. I think next up, Natalie, or Ashley, if you could share, but put up the proposed guideline brown piece again, because I just want to scroll through. There's only a couple of things that we've discussed everything. There are a couple of places where we've kind of proposed two guidelines, and I wanted to put forth some potential options for people, and perhaps we could narrow it down to just one guideline for a particular rule. So if we're up at 4.160A, are we there?
We're on our way. We're almost there.
Okay.
I apologize. It's been a busy day for phone calls.
And are we at 4.160A?
Yes.
Okay. So just wanted to make sure this has been seen by everyone. It's only to clarify what this particular guideline does not rule does not include. I want to make sure everyone has seen that, comfortable with it, no further comment about it.
Ingridina, can you confirm it's 4.160A1?
It's regarding
Correct. The
location.
very first,
Okay, thank you.
very first rule. Yeah.
I have no problem with it.
Okay. All right, so I don't know if Mr. Murphy's hand's up, but Natalie, I trust that you'll let me know if someone is waving wildly. So if we scroll, the next one down is under 6B. And there were actually 2 potential guidelines presented. And I think both of them offer some I think, important clarifications. What I was going to recommend as a potential kind of compromise between the two is I was going to recommend to the committee to look at the first guideline and then add at the very last sentence something that I think is helpful from the second proposed guideline. And that is at the very last sentence, it says to provide a hyperlink to a web page or other document that contains the full required disclosure in the communication, or, and this is the addition, or where impractical to do so in the profile for the social media account. And that's, I think, a very helpful clarification from the second proposed guideline, because there are times where you might not be able to fit the hyperlink into the communication on a Twitter post or the like. But if you include it in the profile, it is always there for those reading the post to see. So again, wanted you to focus on the first one and see what your thoughts were about that.
I wonder how visible profiles are. I have a defensive posture on Twitter, but I never go there. Rarely go to Facebook or any of the others. But a tiny URL link with maybe the word disclosures in front of it would only maybe be 15 characters. And Twitter has expanded. It's beyond 140 character limit now, right?
Correct.
So I'm just wondering if, and there are so many different ways, there's different Twitter reading apps, and I wonder if all of those expose would expose the profile information and this link adequately.
I think as someone who does use Twitter, I think the tricky thing here is just, and not to imply others don't, but the tricky thing is basically, with each tweet, that is a communication out there. Not everyone's looking at all the tweets that's in a longer thread or a link that's being added in a second tweet on top of the first tweet. So there can be a lot of issues within that packed amount of space. What information are you presenting? And let's say if someone's already linking a part of their website to that tweet, there's not more space. You can't attach, 2 hyperlinks, or you can, but one or the other is going to be actually what's visible as an image for someone to click. So again, I think just the thought of profile, and I believe that may have come from my end, from the DEAC, it's something that when there's an important institutional disclosure that needs to be constantly there and permanent in a way, and it may not be able to be in each tweet of a thread to make that equally visible. That's why sometimes it's helpful to make sure and to keep that link in the institutional profile for social media. You're right that it takes more for someone to click that institutional profile versus write the tweet message that pops up. But I think the concern is when you decide, oh, it needs to be in that 280 character limit for a tweet, is is it something, depending on the topic of your tweet or tweet thread, something that has to be in each of them? Are you having to lower priority for other kinds of things you can be giving, or other hyperlinks you plan to give in that tweet, things like that? I hope that helped to clarify.
Another element is just the public protection communication, so that as soon as possible in the engagement with the school, a prospective student can understand the rights and responsibilities of attending that school. So if I live in Iowa and plan to always practice in Iowa in the state court, I would very quickly know this is not the right school for me. Whereas another person would say, hey, I plan to practice only in California. This school has a terrific fit for me. You know, sort of getting that communication early, because also social media is not only small in space, but also can step you through in those small spaces and can step you through quite a way before the perspective has that understanding. And so I think that that's sort of a guiding principle to keep in mind too. And Dean Gardina, Dean Frickberg has raised his hand.
Oh, okay. Jay, thank you.
Just in support of the guideline as it's currently written, my quick count, just the phrase Committee of Bar Examiners of the State Bar of California itself would be 57 characters. So out of a Twitter 280 characters, that's 20% of every tweet being burned up just on the phrase of who the accreditor is, much less accredited by. And I think that'd be very counterproductive, especially when there's a series of communications, each tweet having to have the same disclosure, versus just a requirement of a link of a disclosure where we could have a full explanation for a better understanding. If again, communication and public protection is the real purpose behind this.
Okay, well, I'll just
Thank you,
observe,
Jay.
I just signed into Twitter. And I don't see any profiles unless I have to click on the person's name. So if I'm just looking at a series of messages, I won't see that. I'm not saying that I've made up my mind about what's the appropriate rule here. Just that observing that, you know, it won't be seen, at least in Twitter's basic web interface, unless you go and look at the profile, which you would maybe have no real reason to do if you're just looking at the content of the messages. Would it be possible to define a category of messages that is aimed at potential students, for instance, students and potential students, as opposed to general, you know, just retweeting something about an article about a recent Supreme Court case where that is perhaps less important? Is that a way to draw a distinction?
Well, if you look at the rule, it specifically limits when this has to occur to whenever the words accredited or provisionally accredited appear in a law school communication. So I could imagine a law school, you know, putting out a tweet about a Supreme Court case in which it never identifies that it's accredited or provisionally accredited in the communication. I'm assuming it would not then trigger the need to also include the information.
Oh, that's a good point. Yeah. So we're talking about maybe a subset of law school communications, and asking
Correct.
then the deans, how often do you use the phrase in something like a tweet? It would seem to me perhaps not very often.
It only would come up if you're trying to describe your program to the public, like just for example. So, you know, social media interactions around news articles, of course, it wouldn't necessarily come up. But if you're saying, hey, we have an open house and you're thinking you need to describe what your law school is to those people that you want to let them know about that, then it could come up in that circumstance.
Well, wouldn't you normally be linking to a more detailed announcement on your website anyway?
I would think a hyperlink would be very natural on a tweet for an open house. Absolutely. That could
Yeah.
disclose what
So,
the school is that's holding the open house. So
well, but if you just say we're having an open house at our law school, and
it wouldn't
maybe,
trigger. Right.
right, or maybe you even say accredited, but at that point, you could just refer to, to the hyperlinked page or document, which could contain all these disclosures. Maybe we just need a way to say that.
Well, and I thought that's what the proposed guideline did say, was that it shall be sufficient for purposes of the rule that the communication provide a hyperlink to a web page or other document that contains the full required disclosure.
Yeah.
Yes.
Okay.
It
Okay.
does say
So,
that in the first one. Mhm.
Yes. So and the recommendation was to pull in when it's impractical to do so, to include it in the profile. I hear your comment about that, and your discomfort with whether or not that meets the transparency piece that we're trying to get to in both this rule and ultimately the guidelines as well. So what I hear from you, Paul, is that wouldn't necessarily, in your mind, meet the spirit of the transparency rule.
yeah, because I don't, you're probably directing them to some other document that's communicating your fundamental message. And otherwise you really can't say much to be effective. So I don't think the profile, I agree with myself, the profile isn't the place to do it. It's in the place they're likely going to land because you're directing them there.
So
I don't think, I think
first,
I think
go
the
ahead.
first guideline, the first bullet one, is already good enough. And
yeah,
you don't need to add the addition you were just proposing.
okay, and other thoughts from other members of because we're trying to ask the question, is this the one we would recommend to the CBE?
This is Dean Park, and just speaking, I don't think I see other hands raised. So I think that just again, in terms of a social media presentation, there are times where, again, people want to link to one page versus the other, and they may not be linking to that public disclosures page. So I still see that there's value in the profile. However, hearing what the concern is, and again, knowing that these are scenarios specific for CBE, where it's about when accredited or provisionally accredited is being mentioned, that's a very specific scenario. So I do think the first proposed guideline, that does fit with the specific scenario the CBE is concerned with here. So I'd be comfortable with the first guideline. I still think there is cases where the flexibility of the second can be good, but that's fine if that's more with other contexts.
This is Dean Clancy. I agree with everything that Dean Park said.
Okay, thank you. Jay or Greg, any comments on this one?
Well, I would also be supportive of the first guideline that's proposed. I think it's simpler and it makes sense.
I concur.
Okay. All right, thank you. And so if we continue to scroll down, there was a question about the, I think the length of time here, and Natalie, I provided, and I think this was, and Dean Pritikin was the one who originally raised these questions. And he felt in our conversation that one question is, well, what does the staff and CBE need, and how long do they need the school to maintain it? Kind of from the school's perspective, the less we have to kind of clutter the servers or whatever the case may be, the better. So what was going to be necessary was what was thought. So Natalie, I did present some language to you. And I don't know whether I can read it out loud or whether you can get it up there, but.
I have it up.
Okay, great. So it says schools must maintain records relevant to addressing any areas of non-compliance identified in the prior inspection. And it should say, or longer if directed by the
I'm going to ask
CBE.
Ashley to read it because now my connection's unstable.
Schools must maintain records relevant to addressing any areas of noncompliance identified in the prior inspections and or longer if directed by the CPE. All other data generally need only be maintained for a period of 5 years.
You probably need to carve out grades and whatever else was to be maintained permanently. Just to be clear, you're not modifying that.
Correct. And the 5 years came from FERPA, which also has a requirement regarding permanent records such as transcripts. But I think it's important, as you know, Paul, to reflect that in the guideline as well.
This is Dane Park. Sorry, I was on mute. Is it enough to add at the beginning, notwithstanding student grade records and committee correspondence, you know, which must be maintained permanently? If
Well,
that's,
it says that in the rule, actually. If you look up at the rule on, so Rule 11, it
Oh, yeah.
says the law
no,
school must also maintain sufficient. Yes, got it.
yeah, no, I definitely see that, but I think if the concern of this new guideline, it can't go further or be interpreted, it can't be applying to that. The notwithstanding would clarify that. And going back to the guideline, so, and it's just a suggestion again, if that's a concern. If there is a notwithstanding part added to the beginning, if we feel like that keeps the guideline, the guideline applying to what it needs to, then its schools must maintain records relevant to addressing any areas of compliance identified in the prior inspections. I just want to ask about the and or. Is there a missing word here between the and?
No, it was, I tried to read it out. I said it shouldn't have both in there or longer if directed by the CBE. It's just a typo.
Oh, got it. And then what is the or longer modifying? Is it 5 years or longer, or because I think
identified in the prior inspections or longer if directed by the CBE, giving the CBE the ability to extend the amount of time that someone might need to maintain records related to prior inspections.
Oh, okay. Beyond areas of noncompliance. Let's see. Schools maintain records relevant to addressing any.
So that's the last two inspections, then referring back to
I
the rule.
see. Thank you. That's where I was getting confused. So it should say schools must maintain records relevant to addressing any areas of noncompliance identified in the last 2 prior periodic inspections or longer, if directed by the CBE. That's what it meant to refer to. Sorry, I was getting confused there.
Correct.
And then all other data generally need only to be maintained for a period of 5 years. So,
And obviously the rule statement regarding the need to maintain student grade records and committee correspondence permanently is
affected by this.
The rule. There's no way for the guideline to modify that.
Okay. That helped a lot. Thank you. So if we just understand this guideline wouldn't override anything about the permanent records, then I think school must maintain records relevant to addressing any areas of noncompliance identified in, basically it is the last 2 prior inspections or longer, if directed by the CBE, and all other data generally need only to be maintained for a period of 5 years. That's something I would be supportive of.
Thank you, Jessica. Other thoughts?
I would support it as well for those
Thank you, Mike.
reasons.
Natalie, does staff have any concerns about this approach?
None at this time, and I apologize that my camera is off. Curiously, I too am having a little bit unstable internet, but have heard this discussion.
All right, thank you. So I think next up was Jessica offered some a potential clarification for B6, which was for admissions, related to what does it mean to be reasonably available to the law school. And I think, Natalie, you received some comments from various individuals. I know I provided some and spoke to Marty about it as well. So I don't know whether you've got the rule and the potential clarification as well as the potential language alteration.
Just to speak here and to help as well. So this is 4.160, item 6 for admissions, being the rule. What's up on the screen is possible new guideline language. Information reasonably available to the law school at the time of admission means higher education related information submitted by the applicant within the application process. So just so that's all.
Thank you.
Relayed out to the group. I'm happy to speak on this one just briefly, also watching for time. Originally when I raised this, and I actually forgot that I had raised this way back when I had done the homework, but I actually noted there, I didn't see a present issue to create a guideline for, but I was imagining that there could be one eventually, especially as different technologies. We talked about social media just a bit, but there's some other examples here. As different technologies really exist for assessing law school admits, including what they're publicly posting on social media. One example that I had was, finding out a prospect had news published about their criminal history in state and local news around the time that we were reviewing their admissions. And really that was one case that was really unusual, and I never ran into that before or after that. But that was actually where I had begun to think about reasonably available. I did check in or speak with other registered law school deans and Accredited law school deans, a small group, just on thoughts about is this language confusing to them about reasonably available? Is there concerns? If there's not a guideline, what they sort of are on the hook to check that can be interpreted as reasonably available. And the feedback I got largely was that this wasn't that confusing for them. Even if you can run into a one-off where, you know, I ran into, right, where reasonably available could mean checking out, you know, the local state news about an applicant. That's not really what law schools are struggling with when they're thinking about compliance with this rule. So it is possible at this point, especially if this is not complicated for law schools, to not have a guideline, as really this is something I spotted that could mature or evolve for later. But because of my experience with what I had run through and the thought that other deans perhaps can run into it too, or other admissions departments, that's why I submitted this language that it would be higher education related. But that being said, where I started out from was that I saw this as a potential future issue as technology evolves. It wasn't something that I thought was causing current problems for law school administration. So I really submit that contextual explanation to this group as we look at this. Hope that's helpful. My thoughts are
that is,
it's comfortable not to necessarily have this guideline, but if other deans see similar issues that I did, here's a sentence that can perhaps address that.
Do I understand correctly that this is kind of limiting the scope of what you would consider, in that it has to have been higher education related and submitted by the applicant? So if you were doing the criminal records search that you described, that would be beyond the scope. And is that
Right.
the intent?
Right. Then the intent behind how I drafted that guideline was basically that because the rule says that, you know, a sound policy is one which ensures that the law school does not admit students who are obviously unqualified, do not meet pre-legal education requirements, or who do not appear to have reasonable prospect of completing the degree program or meeting program objectives based on the information reasonably available to the law school at the time of admission. So the thought of interpreting that was basically, well, if a law school is going to be criticized as to having a sound or unsound policy based on what they're reviewing that's reasonably available, that should be somewhat restricted to what they can do, which is what are they likely to be reviewing or having available to them at admissions point. That would be higher education related information submitted by the applicant within the application process. Now, in the situation that I had, I was very happy actually to have a law school staff member have done just a new search on the applicant's name and offer me that information completely outside the admissions process or the admission committee process, but it just had been a voluntary look. So,
but you don't want to be criticized by the bar for not having done that.
Yeah, I think if that kind of information that can be Googled about an applicant is considered reasonably available at the time of admission, there's just a little concern for me of, you know, how much is, well, yes, would that cause an issue of you didn't do your job of checking what was reasonably available at that time?
Okay, so it's a safe harbor.
Right.
We see a hand from Dean Frickberg.
In my reading just of the rule, I don't believe the criminal component would be in play. I think this is more about credentialing for admission and whether or not a school should admit students based on maybe a low LSAT, no LSAT, prior dismissal, things of those nature. And I think this language is sufficient already. You know, reasonable gives each institution the ability to explain why did they do that. So I would not be supportive of a new guideline for this one.
No, that's helpful.
Thank you.
And I think the only reason
Jane,
this comes up is in applications, there can be inquiries about moral character at that point.
And Jessica, I just want to point out that the rule is about the policy that is created. So just want to make sure that we're staying focused on interpreting the rule. And I'm with Jay. I don't know that a guideline is necessary here in terms of the policies that schools might create around their admissions process. And to the extent we do have a guideline, I was very uncomfortable with having it limited to higher education related information, because I think most schools develop and have a very holistic application process that allows them to incorporate professional information, professional history, letters of recommendation, standardized test score, interviews. So I wouldn't be in favor of having it be specific to higher education related information. So I'm with Jay, though, with the starting place of I don't think we need a guideline here.
That's helpful. Again, I think this definitely doesn't restrict people from doing more. Probably the value of having this is just not making it seem like everyone necessarily has to do, let's say, a background check or things like that. So, but I'm again okay with no guideline as well, especially if it's overly prescriptive for different admission processes.
Could I just add one more opinion? This is Dean Clancy. I appreciate the context from Dean Park, but I find that I'm in agreement with Dean Frickberg and Dean Gardina. I think that the rule is clear enough. I don't believe we need the clarification.
Thank you, Mike. I don't know whether, Greg, you have anything to add to this based on your experience.
No, I think the rule is fine. As fine as it is.
Great, okay. So that brings us down to what I believe is number 8. And Natalie, do you want to bring up the staff's position on this, which I think really has to do with authority more than anything else, whether or not this proposed guideline is necessary?
Sure. So this has to do with the first year exam. And the way that the statute was ultimately revised, the allowance for those for whom the June 2020 was their first, second, or third opportunity to take the exam is within that. And because the committee cannot make those changes, only the legislature can, it's already self-executing without this guideline. A guideline change was made initially in the current rule set, but it won't be needed going forward in order to still take advantage of that opportunity.
Thanks, Natalie. So is it the staff's position that because it's self-executing and keeping with our goal of limiting guidelines to those that are necessary, this would be deemed an unnecessary guideline?
That's correct.
Okay. Any counter arguments to that position?
Nope, not at this time.
All right, great. And I think it's important to recognize that the guideline document is a living document, that it is something that will be revisited, I'm sure not just by CSBARs, the staff and the CBE, but once the deans dig in and inspections start with the new rules, that will identify other areas that we need clarification on. So obviously this is not the end point for these kinds of discussions. The last one that we can review is really 4.160C, which is the diversity, equity, and inclusion piece. We received some guidance from the Access and Inclusion Committee in our discussion of this. And again, just for discussion purposes, I was going to suggest proposed guideline number 1 as one to recommend. with the one change, and it's just a word, is to put after number 1, foster student success and recruitment, just so that it's consistent with foster student success, create an inclusive environment, promote cultural competency. So I was just going to put that out there as a starting place for our conversation as the recommendation from CS BARS, and get the committee's thoughts.
Well, Jackie, this is Greg. Generally guidelines, I think should grow out of experience of when you find that there's ambiguities or clarifications necessary. I think the rule is fine as it is without the guidelines. I think experience will teach the committee whether guidelines are necessary or advisable.
Thanks for that, Greg.
Yeah, I don't see it as clarifying much.
Okay.
The first one anyway. Now, the second one has some more details about how they should go about doing it. So there may be some value there.
But my concern is that's sort of like creating new rules in the guise of guidelines. I think schools need maximum flexibility in this area.
Okay, but sometimes the schools though want the bar to commit to safe harbors so that they're not either playing Bring Me a Rock or having a lot of nervousness about whether they're approaching things the correct way or an acceptable way. Maybe there are several, but so am I hearing from the deans that they're not in need of that help at this point?
Could I say for one, and this is Dean Clancy, that I like the attempt at providing clarification as to what's required. I think that the rule is essentially vague as to what the schools need to do. And for purposes of figuring out whether or not a school's in compliance, it seems to me that there needs to be something in writing that provides an indication as to what that is. So I like having something here in the way of a guideline.
And you're speaking more to the second one than the first, right?
Well, the second one certainly provides more, and I think more is better for this rule. Yes.
Now,
Go ahead. Sorry.
Now, reasonable minds can differ, but just remember a months-long conversation and several conversations with COAF members in which schools and public comment wished for less detail so as to make plans that were appropriate for each school, knowing that each school might be a little bit different. Normally, I think safe harbors are desired, but here we also heard a pretty strong countervailing force that flexibility was prized. So I just want to refresh you as to that discussion, and you may or may not feel the same today.
Jay, you were intimately involved in crafting the original rules around this. I wonder what your thoughts are.
Definitely. So I was the primary drafter of these guidelines as well. This is an area of personal interest for me. Do we only want to discuss the first one or more as a group?
It sounds like the first one was just a restatement and we seem to be concluding it didn't really add anything, but the second one does have some details.
Well, contextually, my thought is, and I've been on the receiving end from accreditors for quite some time now, and actually within maybe the last 7 months, I've written 3 self-studies, which are the tool that we use primarily to communicate with accreditors as we go through these functions. And The difficulty I had in looking at it from a dean or administrator position just at the rule is, how can I give the accreditor what they want so that they can weigh to see if I'm compliant or not? I was trying to make more of a silo with metrics, but still not binding every institution to a cookie cutter philosophy that you have to do the following. But you should at least have to have a discussion on each of the following. I'm not as bound to number one. I think number two is the more important one to me. On number two, though, if we could, I think it would be worthwhile to have a continuing conversation. Co-op joined us some time ago, and I think they had some great points that I didn't take into account at that time. As an example, if you look at the categories that are listed, the identified metrics disaggregated in those following categories, I premise that based on IPEDS, which is the national standard for higher education. They thought that, and I thought it was an excellent point, that we're California, we're usually the tip of the spear in evolution and everything. Why shouldn't we go beyond what IPEDS has as well? So I think it'd be great to have a conversation, if everyone's open to it, for a proposed guideline 2. Should we add additional categories that go beyond IPEDS, especially what co-op was bringing to the table for us? Those would be my points.
Other thoughts on this one?
This is Dean Park. I'm looking at another version where I think there was a third version as well. But just looking back here, oh, thank you. There it is. Okay. Just looking at this one, I feel like I would be in support of version 2. I think I take Dean Berg's point as well. It was very helpful to get the presentation to CS bars about ways we can increase dialogue on diversity, or especially have people be more visibly seen if they want to be at their school campuses. But I feel like this is a good starting place, and it's easy to standardize law schools around, at least at a minimum, which is really what this guideline is saying. And I think it's important, especially if this is really a new set. I'm a registered law school dean, so this might not be directly applicable, but I am interested in the evolution of these rules. I think it's great if a clear minimum is set. I can see reasons for counter argument to say you may not want to set that clearly because then everyone will target there. But I think if this is going to be a rollout of a new area where you want to see the progress in a consistent way, it can be helpful to have a minimum, and it can be helpful to give some picture of what's expected based at a national level. And I think what can evolve from there can evolve, but hopefully with more time and more consensus among the group evolving the guidelines.
Thank you. I think my struggle, and I really appreciate Greg kind of speaking to the idea of allowing this to evolve. The rule speaks to the need for there to be a policy. And then I think it's that last sentence that really the guideline is speaking to, which is to ensure an environment of continuous evaluation and improvement. Law schools must track the implementation of their policies and then change them as appropriate. So I'm wondering if at this point, given Jay and Jessica and others' comments about, well, maybe 2 is, or the second one is a good one as a starting place, but it deserves perhaps tweaking or more conversation, that at this point, maybe the committee revisit this, certainly allowing some of our other deans to weigh in now that they've heard the conversation. Certainly would love to craft something and have the access and inclusion team considered as well, given the thoughts that they presented at the last meeting. So I'm wondering how people feel about hitting pause in terms of communicating to the CBE that CS BARS has a clear direction on this one.
Well, Also keep in mind that both staff and the committee are eager to have the feedback because they will be going forward with a staff proposal and committee discussion. So I think that direction now, but also the possibility to accept public comment after this is important. And it can also be revisited as schools turn in the readiness document and there's conversation and there are specific plans on the boards. The document could be adjusted, and I think everyone has been willing to adjust it in a collaborative way because this is a new area. So I'll put that out there.
Thanks, Natalie. So perhaps, Jay, given what you described, I think, Jessica, you had some thoughts as well about how the second one might be more explicitly crafted to respond to some of the Access and Inclusion Committee's thoughts. And people can present their thoughts directly through, and Natalie, will you say once again what the law school regulation email is so people can submit any thoughts on this one directly to you?
Sure, that's lawschoolregulation@calbar.ca.gov. And this is a transition period. Of course, if someone sends it to me or to Ashley, we will also further share.
Okay. All right. So I think we have moved our way through all of the guidelines that had multiple ones associated with them that we wanted to make sure that we discussed and had an opportunity to give the CBE direction. Natalie, do you have enough guidance, and obviously Paul listening to us, to understand where the committee sits in terms of the guidelines as written and proposed by CS BARS?
I feel like I do.
Ditto.
All right. Okay. And it seems like there might be some additional comments coming, not just maybe from CS BARS, but from members of the public who have been listening in to both those, the ones that we discussed, and more specifically that diversity, equity, and inclusion one, which I think is again that rule that is really new to all of us, and probably will be an ongoing conversation, not just with CS BARS, but with the CBE as well. So I know that we have come right to the end of our time here today. So Natalie, as I understand it, we're meeting again in August. Hopefully at that time, we'll have an opportunity to look at what the staff is thinking about in terms of necessary clarifications to the rules. Is there anything else that we'll be addressing at the August meeting as it relates to the guidelines?
I think that will be the key item. And as soon as we can after this meeting, we'll post these comments. And for those that are watching as guests or otherwise review this tape, we would encourage them to submit their feedback as soon as possible, rather than waiting for the staff proposal so it can inform the staff proposal. This won't preclude them from submitting further comments later. So earlier is extremely helpful.
All right. Thank you. And again, I apologize about my internet. It has yet to return. So I apologize for that. I appreciate all of the help that was given by the committee members and Natalie and Ashley to guide this conversation while I've been unable to see. And again, I really appreciate the work this committee has put in over the last 2 years. This committee has created a set of accreditation rules that was submitted to the CBE. We've reviewed and potentially drafted some guidance to help us implement those rules. And it's just been an extraordinary amount of work. So appreciate the effort that everyone's put in and your thoughtfulness and input during this particular meeting. Do I have a motion to adjourn?
Yes, I can move to adjourn, and thank you, Chair Gardina, so much for your work and leadership as well.
I'll second the motion.
Well, all right. And so hearing no objection, we are adjourned. Thank you, everyone.
Thank
Take
you.
care.
Thank you. Good to see you.